Announcements, none. Papers. Papers have been laid. Question.
Announcements?
Announcement.
Yes, announcements.
Yeah.
We are overworked, Prime Minister.
Yes, I
You
can
must
see.
forgive us. Please.
Madam Speaker, it is with sadness that we have learned of the demise of Mr. France-Antoine Canabati, former Member of Parliament, who passed away on the 2nd of October 2025 at the age of 82. He was born in 1943 in Port Louis, and he completed his primary schooling at the Central Boys Government School. He then attended the Royal College of Port Louis for his secondary school and pursued his tertiary education at the University of Manchester as a Commonwealth Scholar. He also held a maîtrise en droit from l'Université de la Réunion and a diplôme du troisième cercle in Cooperation and Development from Université Libre de Bruxelles. Mr. Canabati had a distinguished professional career. Upon his return to Mauritius in 1967, he joined the Collège du Saint-Esprit, where he taught English, English literature, and journal paper. He later became the head of the English department and served as the Dean of Studies until 1990. In 1993, he joined Le Bocage International School as head of the English department and taught English and English literature. He became deputy headmaster before embarking on a new career as a patents translator with the World Intellectual Property Organization until 2025. Madam Speaker, Mr. Canabati joined politics in 1967 on his return to Mauritius. He was elected in Ward 2 of the town of Quatre Bornes at the municipal council elections of December 1982. He was elected mayor of Quatre Bornes on the 1st of January 1984, a position which he held until the 31st of December 1984. He stood as a candidate at the 1982 general election for the Legislative Assembly under the banner of the Alliance MMM-PSM for the constituency number 16, Vacqua-Floréal. He was returned as the second elected member for the said constituency. He then stood for the 1983 general election for the same constituency under the banner of the Mouvement Militant Mauricien, and he became the fourth member for Vacqua-Floréal after having been appointed best loser. Mr. Canabati resigned as a member of the Legislative Assembly in April 1984. Although he was not involved in active politics, he remained a keen observer throughout his life. As a patriot and with a deep sense of civic duty, he translated on a pro bono basis the Mauritius submission to the International Court of Justice. He also edited the book of late J.N. Katari, Behind the Purple Curtain. Madam Speaker, Mr. Canabati will be remembered as a man of high principles and integrity. We offer our sincere condolences to his spouse, Mrs. Usha Dwaka Canabati, to his children and all those who are afflicted by this demise. May I kindly request you, Madam Speaker, to direct the Clerk of the National Assembly to convey the deep condolences of this Assembly to the bereaved family. Thank you.
Thank you. Yes.
Madame Speaker,
Deputy.
je me joins à tout ce que le Premier ministre vient de dire. Madame Speaker, c'est un militant pur et dur qui nous a quittés. En tant que militant, comme nous tous, il refusait les compromissions. Mais en tant que militant pur et dur, il a refusé aussi certains compromis que beaucoup parmi nous, dans le MMM, nous estimions nécessaires at a given point in time. Je me joins à ce que le Premier ministre vient de dire et j'exprime toute ma sympathie à ses proches. Merci, Madame.
Je vous remercie, Monsieur le leader de l'opposition.
Thank you, Madam Speaker. Madam Speaker, on behalf of the opposition, I wish to associate myself to the tribute paid by Dr. the Honorable Prime Minister to late Mr. France Canabati. And Madam Speaker, may I request you to direct the Clerk of the National Assembly to convey our deep condolences to the bereaved family. Thank you.
Thank you. Honourable members, I am also saddened by the passing of Mr. Antoine Canabadi, whom I have personally known during his tenure as a Member of Parliament and also as a friend. I therefore associate myself with the tribute paid to the memory of late Mr. Antoine Canabadi, former Member of Parliament, by the Dr. Honourable Prime Minister, by the Honourable Deputy Prime Minister and the Honourable Leader of the Opposition, and I direct the Clerk to convey the deep condolences of the Assembly to the bereaved family.
Papers have been laid. Question.
Yes, Honourable Leader of the Opposition, your private notice question.
Thank you, Madam Speaker. Madam Speaker, I've given notice, the following private notice question addressed to Dr. the Honourable Prime Minister, Minister of Defence, Home Affairs and External Communications, Minister of Finance, Minister for Rodrigues and Outer Islands. Whether in regard to assaults, he will, for the benefit of the House, obtain from the Commissioner of Police information as to the number of reported cases thereof since January 2025 to date, indicating the number of fatal ones, A. B. Arrests effected in connection therewith, further indicating if suspects are habitual criminals and or suspected of having committed same whilst on bail in respect of other offences or whilst on release on parole. C. Such assaults perpetrated on police officers in the line of duty. And D. Unresolved cases. Thank you, Madam
Yes,
Speaker.
Honourable Prime Minister.
Yes, Madam Speaker. With your permission, I would like to put this P&Q in context, and I would like to remind the House of the chaotic situation prevailing in the police department when we assumed office in November 2024. As the population will recall, the former Commissioner of Police had become la risée de la nation mauricienne by his acts and doings characterized by malfeasance and incompetence, to say the least. As I said before, during the past decade, the police force was turned into a textbook example of institutional decrepitude. The House will recall the scandalous conversations revealed by the Moustache links, where the population found out into its disbelief that the headquarters of the police force was no longer at the Caserne Portly, but in Angus Road, Bakwa. It is not, Madam Speaker, surprising, as we are witnessing since November 2024, how a much broader Machiavellic strategy was put in place to undermine the independence and integrity of our institutions with the sinister motive of exerting absolute control over them. Just like some tin pot dictators, they were hell-bent on transforming our country into an état voyou without caring about the law and order situation. They were more interested in satisfying the insatiable greed for money. I should also like to refresh the memory of the Leader of the Opposition, how the previous Commissioner of Police, with the blessings of the Minister of Interior, the then Minister of Interior, undermined the office of the then Director of Public Prosecutions, Mr. Satyajit Boulel, an act unprecedented in the history of the Commonwealth. The Honourable Leader of the Opposition would also recall how the government, of which he was himself a prominent member, attempted to arrest the former Director of Public Prosecution, Mr. Satyajit Boulel. This was clearly a political act to intimidate him and curtail his independence of action. We recall the abhorrent tactic by the then Commissioner of Police by bypassing the Attorney General's office and the office of the Director of Public Prosecutions for criminal proceedings before our court of law. The Commissioner of Police instead retained the services of counsels and attorneys from the private practice, from the coterie of lawyers and attorneys at the service of the MMM, and the King's Council from the UK for a total amount of 14,288,825 rupees, a totally unprecedented and unheard practice. Unbelievably, the CP even the Commissioner of Police even sued the DPP.
I'm sorry, did you say the MMM or did I not?
MSM.
Okay.
MSM, never the MMM.
No, I know, but
Huh?
there was a slip
Was it?
there was a slip of your tongue.
Was it? Oh,
Sorry to have stopped you.
yeah, no, don't worry.
I just checked everybody
It's
heard
good,
MMM.
it's good you remind people that it is the MSM. It was clearly done. All this was clearly done to undermine the professional integrity of the Office of the Director of Public Prosecutions and other relevant institutions. I leave it to members of the House to ask the question why and at whose behest all these principles were restored to. The revelations regarding the issue of reward money and the allegations of drug planting, targeting members of the civil society, critical of the then government, gives us an idea of the political weaponization of the police force under the previous regime. The involvement of the former Commissioner of Police and his closest collaborators at the helm of the force have sent shockwaves in the nation. Madam Speaker, we find ourselves today in the shameful position where a former Commissioner of Police, 2 Assistant Commissioners of Police, a Superintendent of Police, 2 Assistant Superintendents of Police, a Police Sergeant, other subordinates are currently on bail under charges of embezzlement and corruption of a magnitude never heard before. Madam Speaker, that was the putrescent state of the police force that the previous government bequeathed to the nation. Today, fortunately, that era is behind us. We are restoring direction, discipline, and dignity within the police force. The days when the command of the police echoed from private addresses rather than les casernes are well over. Madam Speaker, when my government came to office, we took a firm and unequivocal stand that the police force must once again embody integrity, fairness, and professionalism. We are modernizing the police through the revival of the National Policing Strategic Framework built around 6 key pillars: community policing, respect for human rights, leadership development, intelligence-led operations, strategic planning, and stronger reactive capacity. Madam Speaker, since his appointment in November 2024, the Commissioner of Police has injected new energy and discipline into the force. His leadership has been guided by professionalism and fairness, and his actions have already produced tangible results. Madam Speaker, the offense of assault, as defined under Section 2281, subsection 1 of the Criminal Code, is such that any person who willfully inflicts any wound or blow, or is the author of any other violence or assault, shall, if such an act of violence has caused any sickness or incapacity for personal labor for more than 20 days, be punished by imprisonment and a fine not exceeding 100,000 rupees. In regard to an aggravated assault, the penalty can go up to 20 years of penal servitude. Madam Speaker, with regard to Part A of the question, from January 2025 to the 10th of October 2025, I am informed by the Commissioner of Police that the number of reported cases of assault is as follows. Simple assaults, 4,247. Assault with premeditation, 112. Wounds and blows causing death without intention to kill, 1. Assault against an agent of civil authority, 104. Attempt at murder, 24. Murder, 24. In spite of the impression that is being created, the statistics for this year clearly show a decreasing trend in the commission of such offences as compared to the previous years. The total number of fatal ones, comprising murder and wounds and blows causing death without intention to kill, is 25. Madam Speaker, with regard to part B of the question, I'm informed by the Commissioner of Police that the number of arrests in connection with those cases is 1,185. The number comprises 108 habitual criminals. The number of persons suspected to have committed the offense whilst on bail or whilst on release on parole is 100. Madam Speaker, in regards to part C of the question, I'm informed by the Commissioner of Police that there have been 95 cases of assault on police officers. As regards part D of the question, I'm informed that 24 of the 25 fatal cases, that is from January to October 2025, have already been resolved. Thus, there's only one case where the investigation is ongoing. This constitutes a success rate of 96%. I wish to inform the House that over the period 2015 to 2024, there are 6 unresolved cases, including the mysterious death of a well-known MSM political agent, Mr. Subramania Krishnan. The case remains unresolved as at date. However, I have commissioned the services of expert homicide detectives from overseas to review the inquiries pursued by the police into the unexplained death of Mr. Subramania Krishnan. Those experts visited Mauritius for several weeks to carry out the review. They have reported, and as we suspected, that the initial police investigations and inquiries were seriously deficient. Critical evidence from the scene was not preserved. It appears even destroyed. Important lines of inquiry were not followed up. Ask yourself why. A judicial inquiry by a senior magistrate was done, and look, it was in the papers. I'm quoting from that, but it is from that. It says, I consider the conduct of the police in this case to be abhorrent. The manner in which the inquiry was conducted fell so below what can be considered reasonable that it marks a new level of incompetence. That is what the magistrate said. After the initial review, that is the overseas experts, which has included seeking the expert opinion of an international forensic scientist specializing in death by fire. I can inform the House that the investigators have concluded there are sufficient indications to conclude that the death of Mr. Subramania Krishnan was neither accidental nor self-inflicted, but he was indeed murdered. Government will not allow the murderers to rest undisturbed in their beds. I can announce that the investigation into the unlawful killing of Mr. Subramania Krishnan will be formally reopened next month, and that the government intends to introduce legislation soon to permit, in certain limited and controlled circumstances and in matters of great public interest, the use of specialists and expert investigators from abroad. I'm informed, Madam Speaker, by the Commissioner of Police that cases of fatal assaults are resolved on an average within 48 hours. This in itself is an indication that the authorities are well coordinating their efforts on the ground to elucidate such heinous crimes. Since my government came to power, and with the appointment of the new Commissioner of Police, there has been a major overhaul in the police department to render it more efficient. Of course, there is room for further improvement. When it comes to law and order, we cannot remain complacent because, as we always say, un crime, c'est un crime de trop. In the last case of murder which shocked us all was in Beju-Tombo recently, on the 2nd of October. It was that of a businessman who was brutally murdered by 5 suspects, including his own son, who was apparently the mastermind. The case was resolved within 24 hours by the major crime investigation team and those suspects arrested. The downward trend is the result of the measures taken by the Commissioner of Police to ensure effective enforcement of law and order, public safety, crime prevention, emergency response, and victim support. I have previously enumerated the measures that have been taken and those which will be implemented in my reply of PNQ of the 19th of June of this year. Amongst others is the setting up of a national crime agency and the introduction of a police and criminal justice bill. Madam Speaker, my government will leave no stone unturned to bring efficiency in the police. As I said earlier, we have already initiated a number of actions to achieve that objective.
Your first supplementary, please.
Speaker, and I hope that I shall be given enough time to put my
Well,
supplementary
we'll do
question.
our best. But
My
go
first,
straight to your question, please.
yes, my first supplementary question, Madam, is with regard to the figures that the Honourable Prime Minister has shared with the House. And when I refer some of the figures, the situation is quite alarming. I can see that we have, from the figures given, 15 cases of assaults per day, and as 10 police officers assaulted per month. That's why I'm saying that the situation is alarming. Now, Madam Speaker, since my last PNQ on the subject, I believe we all agree that the situation on the streets has worsened. For the month of September only, we have cases of assault in the metro, domestic violence, a case of murder, and even the use of firearms and assault with offensive weapons in the premises of a hospital. And the Honourable Prime Minister informed the House. What additional measures is he planning to take to curb that situation prevailing with regard to law and order in the country?
The Honourable Leader of the Opposition might be surprised to learn. I've given the figures, but if you were to compare these figures to last year when you were in power, let me remind you, simple assaults, I said 4,247.
Yes.
2024, you know how many it was? 5,458. Over 1,000 more, 1,300 more. Assault with premeditation was I quoted, 112. In 2024, it was 143. As for assault against an agent of civil authority, I said 104. 2024, it was 133. Let me say this also. We will bring legislation. It is unacceptable that someone should be allowed to assault a police officer. That is something that we will have to address. We will have to tighten the law. That is totally unacceptable. As for murder, attempted murder was, I said 24. It was 25 in 2024. As for murder, 24 this year so far, compared to 35 in 2024. That's why I said there is an impression. But when you look at the figures, it was much, much worse. And I've enumerated, I don't want to go through it, you will say I'm taking time. I've said what are the measures we are taking. As I said, this is always there is room for improvement. Un crime, c'est un crime de trop. But still, we are moving towards that.
Your second question.
Yes, thank you, Madam Speaker. In a reply to a supplementary question from my colleague, Honourable Adrien Duval, last Tuesday, the Honourable Prime Minister said, I quote, he does not want to give the impression that we are a police state because our country attracts tourists. Is the Honourable Prime Minister aware that even tourists are being attacked and robbed in broad daylight? For example, yesterday 2 tourists were attacked at the Promenade Doguet in Port-Louis. Will he therefore agree that if we cannot protect our tourists, Madam Speaker, this will give a very bad reputation to our country and we will have to face...
Again, I said to the Leader of the Opposition, as if nothing happened, no tourists were attacked for the last 10 years. As I said, there is room for improvement. We are tackling, the Commissioner of Police is looking into all this. When I said I don't want to give the impression that it is a police state, but we are using the SMF, we are doing these routine checks and all this are going on, but not to everywhere over the whole island. We are changing spots from time to time.
Third question, please.
Madam Speaker, in my last PNQ, the Honourable Prime Minister mentioned the lack of police officers in the force. While today we are asking police officers to register dogs, may we know where matters stand regarding recruitment of new police officers?
As I said, I think the delegation didn't hear me last time. We have just recruited, I can't remember, a whole batch of new police officers. And we are in the process of saying, but we have to do one thing. We want police officers to deliver also. We want people to respect police officers, but the rogue police officers, we will get rid of them.
Madam Speaker, and this is confirmed, Madam Speaker, as per my information, more and more police officers in the force are dejected with the present situation. May we know what proposals have been made by the Office of the Prime Minister to the PRB and the DFSC to improve working conditions of police officers, that is, hours of work, equipment and salary?
I know the Commissioner of Police is putting order. Of course, some people won't be happy when he's putting order. You can't just decide to work on a Sunday just to get extra money. He's putting order on all this. Reward money. You're stopping this. You're stopping this. We can't give reward money like it did. You saw how many millions? You must have been shocked yourself. Because you were not the Home Minister. I don't think you were.
Another question? Yes. You got 10 minutes left. 10 minutes.
Yeah,
Okay.
I've got a lot of questions, Madam. Many units such as the SSU, the SMF are still underutilized, Madam Speaker, despite the answer given by the Honourable Prime Minister to my first BNQ on the same subject matter. Will the Honourable Prime Minister consider deploying these special units now across the country in order to stop this crime wave prevailing in the country?
This is what I said earlier, Madam Speaker. I did say that the Commissioner of Police is looking. Don't forget what the Constitution says, Section 71. I can give general direction, but it is for the Commissioner of Police to determine the use and control of his force. And he is doing it. That I'm satisfied.
Okay.
Yes. The Honourable Prime Minister in his reply made mention about PACE, that is the Police and Criminal Evidence Bill. Can we, Honourable Prime Minister, finally have a time frame?
I might have to remind the leader of the police that I brought the then Attorney General, Mr. Razak Pirou, on my demand. We worked very hard on it, and we brought the Police and Criminal Evidence Act here in Parliament. It was read the first time. There were some queries by the then DPP, and then the election came. That bill had been already read the first time. Now you had 10 years in government. The bill was there. You never brought that bill. And now you're asking me for time. You can see for yourself.
Yes.
In a reply to a question last Tuesday again, the Honourable Prime Minister stated that he would consider the use of body cam by prison officers. Will he consider extending same to police officers?
Yes, we actually are.
Good.
Will the Prime Minister also consider introducing in our penal system the use of electronic bracelets for habitual criminal and sexual offenders?
That I think, as far as I remember, it had already been started, but we will definitely extend that. As I said, Madam Speaker, we inherited a police force totally upside down. So we can't do everything at one go. I don't have the magic wand, as I keep saying. But this also is being considered.
Madam Speaker, the Honourable Prime Minister cannot indefinitely blame the previous government. He has been in office for the past almost a year now, Madam Speaker. Madam Speaker, the very existence of gangs in the country, such as Mauritius, is not acceptable. We have specialized units such as the JPM, the Marcos at our disposal. Will the Honourable Prime Minister consider conducting dedicated operations to dismantle gangs and put the perpetrators behind bars once and for all?
As the Deputy Prime Minister reminded me, there is no striking team there anymore. But, each unit has its own protocol, and when you use it, for example, JPM, they have their own protocol, but we are looking at all this.
Now, Speaker, since the case of assault that occurred in the Metro Express, can the Honourable Prime Minister inform the House if police presence in the Metro and at Metro Station has increased, and what solid measures have been taken to protect at the same time the commuters and the employees of the transport sector?
I did say that, I addressed that question in the past. The problem is, Madam Speaker, as you've seen, the FCC is asking for more police officers to do their work, because there are so many people have stolen from the previous government that we have to look for people. And they have to be trained. We can't just take a man from the street and say, become a policeman. They have to be trained.
With regard to firearms, Madam Speaker, will the Honourable Prime Minister consider conducting a national survey and a crackdown operation on illegal possession of firearms? And if yes, how does he intend to proceed?
On legal ones? Illegal or illegal ones?
Yes, that we had done before when I was Prime Minister. We're going to do it again. It is being done. Others say we can't do everything at one time, but there are some people very close to you who have been shown to have fishy.
I heard a comment with regard to Fusillelo. Can the Honourable Prime Minister confirm to the House whether the revolver used at Grand Bay was one with a silencer?
How will
I be able to say
How will
that?
he know?
Speaker, it is something very serious, Madam Speaker.
No, but some
Many
things-
of our senior citizens, some even of foreign nationality, have been brutally attacked in their homes. Will the Prime Minister consider a special desk in all divisions across the country to assist those persons, such as regular visits or exchanges, Madam Speaker?
One of the reasons this is happening, because under the previous regime, drugs were available everywhere.
Yeah.
The case of the unfortunate case at Bejitombo, the son who was arrested, he was looking for money to buy drugs. This is the origin of the problem.
Let me come to that
Perhaps
one.
one moment. Maybe you want to consider this special desk?
I would love to
Interesting.
discuss this with the Commissioner of Police.
Yes.
Thank you, Madam Speaker. Based on the figures provided by the Honourable Prime Minister himself, assaults seems to be a daily occurrence. And we have not even spoken about crimes related to drug trafficking and drug use. But I will come to that at a later stage. 1 year down in his mandate, is the Prime Minister satisfied with measures that have been taken by his government to fight crime in this country?
I thought I explained all this at the beginning, Madam Speaker. We have results to show, compared figures. We have, for example, I gave you a figure on describe 96% success. Never happened under your government.
2 minutes left. 2 minutes
Got
left.
one last question for
Yes.
the Prime Minister. I come back to what I said last time in my PNQ. Can the Honourable Prime Minister inform the House when does the present contract of the Commissioner of Police come to end and whether he intends to renew his contract?
This is too early for me to say that. He's doing his work. Let him do his work.
Okay, thank you. Thank you very much, both of you. Yes?
Speaker, I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Seconded, yes. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye. Aye. Those against say no. The ayes have it.
Statements by ministers none. Public bill first reading.
Honourable Attorney General.
I move that the Senior Counsel and Senior Attorneys Bill be read a first time.
Public bill second reading.
It had to be seconded. Yes, I'm sorry. Okay. Second reading.
Madam Speaker, I move that the Senior Counsel and Senior Attorney Bill be read a second time. Madam Speaker, I never thought I would be bringing such a bill before this House whilst I was Attorney General, whilst I am Attorney General. It was never my intention, nor part of my instructions when we were preparing the government's programme, to do so. There were other enactments which we were looking at and which we have, some of them have already been passed this year. However, here we are today with a proposed legislation to clarify and improve the process for the appointment of senior counsel and senior attorneys. One born out of necessity and forged in a spirit of dialogue. One which I hope will put to rest the utter confusion that has reigned recently on the subject. But first, Madam Speaker, allow me to address a vital question. How did we get to this? You see, the tradition of conferring titles upon lawyers did not begin in our part of the world. It began, as many of our legal habits did, like addressing the Chief Justice as my lady, in England. The title of King's Counsel or Queen's Counsel, depending on the sovereign, first appeared in the early 17th century. It was a recognition of seniority, skill, and service to the crown, and for centuries it remained one of the most visible markers of professional distinction at the English bar. Originally, the title was a personal mark of favour, of royal favour, granted directly by the monarch on the advice of the Lord Chancellor. It was not the judiciary that conferred it, but the executive acting through the sovereign's prerogative. After all, it was the King's or Queen's Counsel. Yet the courts themselves quickly gave it life. They recognized the precedence that came with the title and allowed those appointed His Majesty's Counsel learned in law to enjoy privileges that ordinary counsel did not. They were heard first in court. They sat within the inner bar as opposed to the outer bar, and they wore silk gowns, hence the term that survives to this day, taking silk. Those privileges, though symbolic, were not without consequence. They signified a degree of mastery of advocacy and of trust in the advocate's independence. Today in the United Kingdom, the system still bears the imprint of its royal origins, but it has been modernized to reflect democratic and merit-based principles. The appointment is now handled by an independent body. Applications are invited publicly. Candidates are assessed against clear criteria, including integrity, understanding of the law, excellence in advocacy, and contribution to the profession. Recommendations are made to the Lord Chancellor, who then advises the King. And we all know who the Lord Chancellor is and where does he sit in Parliament. You will have noted, of course, Madam Speaker, that the Lord Chancellor, being the Minister of Justice in the United Kingdom and a member of Cabinet, the role is that of an executive, of someone of the executive. The final step is the issue by the King of letters patent, but the process itself is essentially the result of the work of the independent panel, which includes lay members alongside judges and senior lawyers. The idea is to ensure that excellence at the bar is recognized by society at large, not merely by the profession itself. Now, across the Commonwealth, the model evolved in different ways. In some jurisdictions, especially those that have become republics, the title of King's or Queen's Counsel have been replaced by the title Senior Counsel. In Australia, for instance, Senior Counsel are appointed by the Chief Justices of each state, often upon the advice of a selection committee that consults widely amongst judges, peers, and the profession. The criteria are again merit-based, demonstrated ability in advocacy, integrity, and independence. In Canada, the evolution followed a somewhat different path. The title of Queen's or King's Counsel remained, but responsibility for appointments passed to provincial governments under statute. In most provinces, the Attorney General or Cabinet makes the appointment, sometimes following the advice of the Chief Justice or of an advisory committee composed of senior members of the bench and the bar. Eligibility criteria are often codified: a minimum number of years in practice, record of integrity, significant professional achievement, contribution to the administration of justice or to the community. Let us take the precise examples of British Columbia in Canada. The King's Counsel title is conferred under the King's Counsel Act by the Lieutenant Governor in Council, acting on the recommendation of the Attorney General. Before making any recommendation, the Attorney General must consult a small advisory group composed of the Chief Justice of British Columbia, the Chief Justice of the Supreme Court of British Columbia, and 2 lawyers nominated by the Law Society. In practice, this group is supported by a broader advisory committee. The Attorney General retains the final discretion to advise Cabinet. India's system for designating senior advocates, roughly analogous to our Senior Counsel, had long been criticized for arbitrariness and lack of transparency. In the case of Jai Singh in 2017, petitioners challenged the existing practice as a beauty contest because the process lacked objective criteria, public call, or reasoned rejections. As a result of that litigation, the court framed guidelines of 2018 for designating senior advocates. Under those guidelines, a permanent committee for designation of senior lawyers was to be constituted, comprising the Chief Justice of India as chair, 2 senior Supreme Court judges, the Attorney General, and a bar member nominated by the chair. Applications are evaluated via a secretariat that collects data on reputation, volume of work, nature of work, advocacy record, and professional standing. All this is then forwarded to the committee for its decision. Madam Speaker, I could go on and speak about Singapore, Hong Kong, South Africa, but it would belabor my point, which is there is a great variety of systems in place around the world in established democracies, and they all have chosen particular combinations of roles for the judiciary and or the executive and or their professional peers. Now, let us see what avails here today. In Mauritius in 1984, the Law Practitioners Act did not provide for the titles, as the British awards of QCs were still in place. Things changed with the advent of the Republic. In 1992, Counsel Emeritus and Solicitor Emeritus were introduced in Section 9A of the Law Practitioners Act, and their mode of designation was one we still use today. The said Section 9A was, by virtue of Act 6 of 1995, amended, and the appellations of Counsel Emeritus and Solicitor Emeritus were changed to Senior Counsel and Senior Attorneys in 1995. And in 2001, Section 9A was again amended to provide for a minimum of 15 years standing as sole eligibility criteria for appointment. Therefore, Madam Speaker, under the current law, the appointment of Senior Counsel and Senior Attorney is a shared process between the judiciary and the executive. Section 9A of the Law Practitioners Act provides that the President may, and I stress the word may, as opposed to shall, on the recommendation of the Chief Justice, appoint barristers and attorneys to these honorary titles. The word may is key. It means the President retains a discretion, but a discretion limited to the recommendation, nothing more. There is no power to add to the recommendations. And under Section 64(1) of the Constitution, the President exercised that discretion in accordance with the advice of Cabinet. In other words, the Chief Justice recommends, but the President, acting on Cabinet's advice if he so wishes, decides. It is therefore a collaborative process, not one belonging exclusively to either branch. The judiciary identifies merit, the executive ensures propriety, and acts through the head of state. Together, they give effect to a constitutional balance that respects both independence and accountability within the separation of powers. But truth be told, its application has never been easy or straightforward. I'll concede that. In June 2010, then Chief Justice Young Sik Yuan broke a 15-year silence in the appointment of Senior Counsel. Only two had been named since 1995, and this was in 2003, creating what he called a barren period. His decision to recommend 16 new appointees as Senior Counsel at once was, in his own words, and I quote, an act of corrective justice, meant to restore balance after years of stagnation, to replenish the ranks of seniors at a bar that had grown in size, and to ensure that the profession could transmit its best traditions to younger lawyers. The then Chief Justice therefore introduced a method that was his own, but it had its merits. He said that he undertook written consultations with all judges, all QCs, and all senior counsel. And he relied on guidelines which had been drawn up after discussions with the Bar Council and the Law Society. Chief Justice Sik Yuan wanted these guidelines published on the Supreme Court website for the sake of added transparency. This practice, it would appear, Madam Speaker, has not been followed since. In fact, Madam Speaker, there have been many difficulties over the years in the appointment process. In the last 32 years, this exercise has been carried out on very few occasions. 1993, 1995, 2003, 2010, 2016, and in August of this year. I have been informed that the 2016 nominations were the subject of a back and forth between the President and the Chief Justice of the time, leading some to questions whether the process had been followed by all. I also know for a fact, Madam Speaker, that under the previous government, recommendations of the then Chief Justice were not acted by the President at all, a decision which he was entitled to take, but which left, of course, a bitter taste for many in the legal and judicial sphere. Madam Speaker, over the years, the recommendation process became seen as a burden for the different heads of our judiciary. None were willing to single-handedly pick names and then potentially engage in a tug-of-war with the executive without mentioning the criticism from those that were not picked. The situation became such that upon stepping in as Attorney General in November 2024, I immediately started discussions with the Honourable Chief Justice on this issue. I put forward the fact that no new appointments had been carried out since 9 years, and I pledged to support any efforts she would undertake to remedy this. Madam Speaker, unfortunately, once again the appointment process for senior counsel and senior attorneys has reached an impasse. A few months ago, recommendations were submitted to the President in a list of 33 names of counsel and attorneys for appointment. Acting under Section 9A of the Law Practitioners Act, the President appointed 31. He did not add any new names. The President simply declined to act on 2 recommendations. And I can say, Madam Speaker, that the President was, in law and conscience, perfectly entitled to act as he did. What followed, however, was gridlock. No ceremony to hand over the letters patent, apprehensions on whether the process was valid, a judicial review based on these apprehensions, all paralyzing what ought and should be a very simple process of collaboration between 2 branches of power in Mauritius. But mistrust, speculation based on misinterpretation of the existing law cannot be allowed to endure, Madam Speaker. This bill before Parliament, therefore, seeks to restore clarity, transparency, and institutional balance. This bill remedies the shortcomings of the existing Section 9A of the Law Practitioners Act by replacing a system centered on a single office holder with a structured collective process. Its central innovation is the creation of a recommendation panel, as we have seen avails in most Commonwealth countries, which will replace the Chief Justice acting alone as the body responsible for proposing name to the President of the Republic. Madam Speaker, under Clause 4.3 of this bill, the panel will consist of the Chief Justice's chairperson, the senior appointed judge, and the next 2 senior-most judges, therefore the numbers 1, 2, 3, and 4 of the Supreme Court. The Attorney General, the chairperson of the bar, and the President of the Mauritius Law Society Council. And where any of the 2 professional representatives is not a senior counsel or a senior attorney, their counsel must designate one who is. This ensures that the voices of both branches of the professions are represented. There is a provision for a quorum of 5 members on the panel and a possibility for designated replacement should conflicts of interest make a quorum impossible. This is therefore a clear mechanism to avoid the stagnation of the past. The eligibility threshold for our appointments, 15 years, remains unchanged. Madam Speaker, under Clause 3.1, a nominee must have been a barrister of an attorney for at least 15 years, and his name must not have been erased from the roll of law practitioners. Clause 3.2 makes it explicit that non-practicing barristers may be appointed, recognizing that some who have served their country in public office or other capacities continue to embody the distinction and contribution that the title seeks to honor. The bill also makes it clear that the title of senior counsel or senior attorney is honorary and creates no legal right or entitlement. The bill introduces for the first time a regular timetable for appointments. Under clause 6.1, Madam Speaker, the panel will meet as and when required, but it shall, in any case, every 3 years make recommendations, if any, to the President. There might not be anyone to recommend, but they must at least meet and decide that there are no one who can be recommended. In its deliberations, the panel will be guided by broad, merit-based criteria as set out in clause 6.2. The criteria, Madam Speaker, include contribution to the development of the law, special skill or expertise in the legal field, academic or professional distinction, good standing in the legal fraternity, and personal qualities of competence, integrity, and fairness. Clause 7 provides for a ceremony at the Supreme Court to confer the letters patent issued by the President to the new appointees. No more gridlock. The remaining provisions regulate the use of the honorary title and provide for its cancellation where a practitioner is struck off the roll or otherwise ceases to be qualified as a law practitioner under the Act. In essence, Madam Speaker, the bill widens the base of recommendation, diversifies participation, replaces opacity with procedure, and it introduces a framework that blends judicial leadership with professional representation and constitutional oversight. Madam Speaker, having elaborated on the why this bill was needed and what it contains, I will now, with your leave, address two important subjects of ongoing debate, or should I say ongoing confusion on the subject. First, Madam Speaker, is the idea that we are somewhat depriving the Chief Justice of inherent prerogative of her office. I stress inherent prerogative. An inherent prerogative, Madam Speaker, is one which, even if not defined in statute, must necessarily exist for an institution to fulfill its role. For instance, the Supreme Court decision in Gimel in 1993 recognized that admitting or removing a barrister from the role is an inherent disciplinary function of the judiciary. That is, a power essential to maintaining the integrity of the court and therefore part of its core judicial authority. That arises because the courts must be able to control who appears before it as an aspect of administering justice. The designation of senior counsel, however, Madam Speaker, is of an entirely different nature. It does not determine whether a person may practice, nor does it discipline or regulate advocates. It is an honorific recognition of standing and contribution created purely by statute under Section 9A of the Law Practitioners Act. It confers no special right of audience and does not affect the exercise of judicial power. Crucially, as we have seen, the law provides that such appointments are made by the President after receiving the recommendation of the Chief Justice. By contrast, the admission or removal of counsel from the role of barristers lies exclusively within the court's jurisdiction. The executive has no part to play in it. This clear difference confirms that the appointment of senior counsel is administrative and collaborative, not an inherent judicial prerogative like the admission on the roll, and the two issues must not be hastily conflated. Indeed, Madam Speaker, the designation of senior counsel or senior attorneys is not a judicial function because it does not involve any exercise of judgment over legal rights, the interpretation of the law, or the resolution of disputes, which are they not, the essential elements of judicial power. Thus, nothing in the Constitution or in the inherent powers of courts creates or implies such a function. Its source is therefore purely statutory at Section 9A of the Law Practitioners Act. In other words, the judiciary's role here exists only and only because the law expressly provides it. There are no inherent powers in the judiciary for that function, which is not a judicial function. Secondly, Madam Speaker, some have sought to rely on the Indian case of Jai Singh in 2017, which I mentioned earlier, one of the very rare authorities on the issue, to argue that the power to designate senior advocate is inherently and exclusively vested in the courts. Very far from the truth, I'm afraid, Madam Speaker. Such a view is, in my humble view, most incorrect. The actual issue in Jai Singh was how the courts should exercise their statutory powers, not who, executive or judiciary, possessed the powers. That was the ratio decidendi of that case. Jai Singh confirmed that the power to designate senior advocate comes from statute, the Advocates Act, just like we have the Law Practitioners Act in Mauritius. The court treated it as a statutory function, not a judicial function, one that must be exercised with fairness, transparency, and clear criteria, and issued guidelines to ensure that standard. And when the Jai Singh judgment says that the power, and I quote, is always vested in the judiciary, it was merely and only saying that the Indian statute already says so, and that there was no need for the new guidelines to re-establish it. In fact, Madam Speaker, to say otherwise, that is to argue that such a process is necessarily part of the exclusive functions of the judiciary, would be to imply that somehow any other country, any state, where the judiciary does not hold complete control of the process, is encroaching on the prerogatives of its judiciary. So from Canada to England, dangerous breaches of the democratic principles would thus be taking place and be accepted by the courts. Does it make sense, Madam Speaker? The answer is a resounding no. Madam Speaker, clear rules, balanced participation, avoidance of gridlocks. This bill restores order in a climate of confusion and distrust. Each branch will have its role. The judiciary will lean on assessing merit, assisted by the bar. The President will continue to act as guardian of the Constitution. That is the choice of balance which we have made. The bill is not about power, Madam Speaker. It is about putting things right. We are not here to defend habits, but principles. The rule of law is not weakened by clarity. It is strengthened by it. Mauritius deserves institutions that work together, and this bill helps them do just that. I therefore commend this bill to the House.
Seconded. Yes. Deputy Prime Minister again. Yes. Honourable Leader of the Opposition, you're on my list. Yes, please.
Madam Speaker, I rise today in this August Assembly as Leader of the Opposition to express my deep concern on the Senior Counsel and Senior Attorney Bill. Je ne suis pas contre le fait qu'on revoie le processus de nomination des Senior Counsel and Senior Attorneys, mais je suis contre cette proposition de loi en tant que telle. Mon premier point, Madame la Présidente, ma première réflexion, c'est sur le timing de la présentation de cette nouvelle législation. Quelle est l'urgence de présenter ce projet de loi? Est-ce plus important de nommer une cinquantaine de senior counsel ou de senior attorney que de résoudre, par exemple, on en a entendu tout à l'heure là, le problème de law and order dans le pays, ou de voir comment réduire la cherté de la vie, ou de résoudre les problèmes d'indiscipline et de bullying dans nos écoles. Madame la Présidente, le peuple est asphyxié depuis des mois par la hausse des prix, mais ce gouvernement trouve le temps de faire un special cabinet meeting un lundi, juste pour finaliser ce projet de loi et de le circuler le lundi soir. Ce gouvernement a trouvé du temps pour la préparation de cette loi, mais ne trouve pas le temps pour nommer la Constitutional Review Commission. Pourtant, Madame la Présidente, voilà ce que dit le paragraphe 8 du Government Programme. Government will appoint within 6 months a Constitutional Review Commission which will make recommendations on constitutional and electoral reforms as well as on enhanced protection of fundamental rights. Within 6 months, avait-il dit, Madame la Présidente. On est presque à 1 an des dernières élections. Par contre, en 1 an, ce gouvernement a revu les pouvoirs de 2 fonctions constitutionnelles. A commencé par l'amendement, le projet de loi concernant le Public Inquiry Act, qui a éliminé l'institution des commissions d'enquête. C'était le président qui avait le pouvoir d'instituer une commission d'enquête. Et aujourd'hui, Madame la Présidente, on est appelé à revoir le pouvoir de la chef juge ou des prochains chefs juges. Madame la Présidente, this bill is not simply an amendment to the law. It goes to the heart of the independence of the legal profession, the integrity of our judicial system, and the trust of the public in the administration of justice. Why the urgency to legislate? My first question, Madam Speaker, has there been adequate consultations? Have the Bar Council and the Law Society been consulted? Have barristers, attorneys concerned by the changes, have they been given enough time to reflect on this piece of legislation and voice out? Madam Speaker, this bill has been in circulation since about 1 week only. It is therefore with deep concern that I take note that this bill is being introduced at a time when a case of judicial review is pending before the Supreme Court concerning the very process for the appointment of senior counsels and senior attorneys. And this, to me, Madam Speaker, raises serious questions of principle. Whether the timing of this bill respects the separation of powers and the independence of the judiciary, and whether it risks creating the perception that the government is seeking to preempt the court's decision, Madam Speaker. Ce gouvernement ne respecte rien. Ce gouvernement contrôle la législature. Maintenant, il veut petit à petit grignoter sur le judiciaire afin de s'en assurer le contrôle. Madame la Présidente, c'est l'infiltration du gouvernement au sein du judiciaire qui devrait nous inquiéter. Ce projet de loi vient ouvrir une ère de tractation et de manigance, Madame la Présidente. Et ce projet de loi vient politiser le judiciaire. On the surface, this bill pretends to enshrine merit and transparency in the conferral of honorary legal titles. But beneath that surface of reform, we find a structure that risks undermining the very values it claims to protect: independence, fairness, equality of opportunity within our justice system, and more importantly, Madam Speaker, the system of checks and balances that guarantees the separation of powers between the legislative, the executive, and the judiciary. Nous considérons aujourd'hui le projet de loi le plus scandaleux de cette législature. Le gouvernement vient confirmer sa volonté de s'ingérer continuellement dans le fonctionnement des institutions de notre pays. Après l'ingérence du gouvernement dans la Local Government Service Commission pour priver 2000 travailleurs de leur emploi au sein des collectivités locales, après les ingérences du ministre du Sport dans les affaires du comité olympique mauricien, et après avoir nommé un juge sans consultation avec la chef juge comme inspecteur spécial dans l'affaire afrinique, voilà qu'ils veulent s'ingérer maintenant dans le choix des senior counsel et senior attorneys. Une sinistre intention d'empêcher et de favoriser tel avocat. Nous savons, Madame la Présidente, comment le leader du MMM, lors d'une régionale de la circonscription numéro 11, avait expliqué pourquoi un certain avocat ne méritait pas d'être senior counsel. Est-ce que le nom de cette personne, pose la question, a été enlevé après intervention politique? Je me pose aussi cette question. Est-ce qu'il est une victime puisqu'il est le représentant légal de certaines personnes ou de certaines compagnies, Madame la Présidente? Que veut faire le gouvernement à travers l'Attorney General, qui n'est que le porte-voix du Premier ministre pour présenter ce projet de loi? Pour moi, avant tout, c'est infiltrer le judiciaire. Sous la section 9A du Law Practitioners Act, c'était la chef juge qui recommandait au président de la République la nomination d'avocats et avouait à la distinction de senior counsel et senior attorney. La tradition a toujours voulu que les chefs juges consultent les juges et certains seniors de la profession. Mais il n'y a jamais eu de consultation avec le pouvoir, et le pouvoir se gardait bien de s'ingérer dans cette prérogative du chef juge. C'est ainsi, Madame la Présidente, par exemple, que Sir Siusaga Ramgoolam avait conseillé sans broncher le gouverneur général de l'époque que Sir Anirudh Jagannath, alors leader du MMM et candidat à la succession de Sir Siusaga Ramgoolam, soit élevé au rang de Queen's Counsel sur la recommandation de Sir Maurice Rowe. De même, Madame la Présidente, sur la recommandation de Sir Victor Glover, le père de l'actuel Attorney General, Sir Anirudh Jagannath n'avait pas hésité à conseiller au président de la République que Ivan Kolendavelou soit élevé au rang de senior counsel, alors que Ivan Kolendavelou était à cette époque secrétaire général du MMM et en grande opposition à Sir Anirudh Jagannath. C'était cela, Madame la Présidente, le sens de l'État. C'était cela, le respect des institutions. Et c'était cela, le respect de la séparation des pouvoirs. Et si, demain, posons-nous la question, nous nous retrouvons dans un cas où un ministre démocratiquement élu détient aussi les fonctions d'Attorney General, comme cela a déjà été le cas dans le passé, et que ce ministre répond à tous les critères pour être senior counsel, who will sit on the panel, that is the recommendation panel. Even more worrying, Madam Speaker, is the inherent conflict of interest. The Attorney General, a political figure, will sit on the same panel that determines who among the legal profession should be elevated. Can we seriously claim independence when a government member helps decide who receive titles of honor in the profession that so often challenges government itself in court? En d'autres mots, Madame la Présidente, le loup est dans la bergerie. I do not agree that Attorney General sit on that recommendation panel because, first of all, he represents the executive, and his presence on that panel would, to say the least in the Mauritian context, give the strong perception which would distort the concept of independence of the appointment process and the separation of powers. 2, he is an unelected political nominee. 3, he is the principal legal advisor of government and drafts bills to be enacted in Parliament, and he sits in cabinet and participates in its deliberation and its decision-making process, Madam Speaker. Madam Speaker, I will make some further comments on the Attorney General sitting on the recommendation panel later. Now, at section 4, where A, the chairperson of the Bar Council is not a senior counsel, the Bar Council shall designate a senior counsel to form part of the recommendation panel. B, the president of the Mauritius Law Society Council is not a senior attorney. The Mauritius Law Society Council shall designate a senior attorney to form part of the recommendation panel. The present Attorney General is a senior counsel. However, Madam Speaker, the next Attorney General may not be a senior counsel. So, will it be a council nominating a senior counsel, Madam Speaker? Section 4.3d provides that the Attorney General shall form part of the recommendation panel. Apart from the principles at stake regarding the separation of powers, it is only coincidental that the present Attorney General, like I said, is himself a senior counsel and a counsel of repute, Madam Speaker.
Wow.
But what if the Attorney General of the day is a young member of the bar, or even if experience is not a senior counsel? Will that young Attorney General not be tempted, first of all, to nominate himself? Or his friends, Madam Speaker? Je me réfère à la section 5A et 5B. Le choix de nommer un senior counsel et senior attorney par le président de la République, ou au cas où le Bar Council et le Mauritius Law Society Council ne peuvent prendre une décision, qui va représenter leur organisation pour siéger au sein de ce recommendation panel est éminemment politique, Madame la Présidente. La nomination par un président ou une présidente de la République est politique. Il agit dans la plupart des circonstances selon les recommandations du Premier ministre. Ces choix de senior counsel et senior attorney pour siéger sur le recommendation panel sera tainted of political motives, Madame Speaker. Madame la Présidente, dans le contexte mauricien, ni le président du Bar Council, ni le président du Law Society ne doivent former partie du recommendation panel, et je vais vous expliquer à la Chambre pourquoi je pense comme ça. We live in a small country, Madam Speaker, where everyone interacts with everyone. and has views and opinions about everyone and everything. First, this bill does not impose a duty on them to consult the Bar Council and or the Law Society. Now, even if the Bar Council or the Law Society were to be consulted in a meaningful manner, they are not competent, independent, and impartial to judge whether a peer is competent to become a senior counsel or senior attorney. They may have ulterior motives. They may dislike a candidate. They could have a political motive. This is certainly not how King's Counsel are appointed, for example, Madam Speaker, in the United Kingdom. At any rate, the appointment of a senior counsel or senior attorney can only be considered by their peers who already are senior counsel or senior attorney. This is already provided for in clause 6.3 of the bill. Madam Speaker, the proposal that I made is to delete clauses 4.3d, 4.3e, and 4.3f of the bill, and by deleting those three clauses, clauses 4.4 and 4.5 then become redundant and also must be deleted, Madam Speaker. Now, since we recommend that the composition of the recommendation panel only consists of the four members of the judiciary, we propose in clause 4.7 that the panel can be convened by the Chief Justice or at the request of two members, therefore making it a quorum of 3 members, Madam Speaker. Now, with regard to the appointment of non-practicing barrister, Madam Speaker, I do not agree with clause 3.2. That is, the appointment of a non-practicing barrister or attorney as senior counsel and senior attorney, because first, this is unfair and arbitrary towards law practitioners in practice and undermines the selection process, which has to be rigorous. Should the recommendation panel appoint any such non-practicing barrister or attorney as senior counsel and senior attorney, which includes a minister in office, given the reality in Mauritius, this would give the strong perception that the judiciary is favoring the executive and undermine the concept of independence of the judiciary and separation of powers. And if the judiciary were not to appoint such a person, then this would lead to animosity and tension between the executive and the judiciary. Now, Madam Speaker, in clause 2, the definition section role is defined as the role kept under section 10.1 of the Law Practitioners Act, which reads, the registrar shall, for the purposes of this act, keep a roll of law practitioners in such form as the Chief Justice may approve. This is the roll of the date of call of every law practitioner, but exclude the list in section 10.4 of the Law Practitioners Act, meaning barristers in private practice, legal offices, law firms, and their practitioners, law practitioners in employment, and legal consultants. Therefore, Madam Speaker, clause 4.11 must be deleted as it fetters independence of the judiciary. In clause 5, Madam Speaker, on conflict of interest, I propose that clauses 5.2b, the Attorney General, and clauses 5.2c and 5.2d be deleted for the reasons that I have already given above, Madam Speaker. Now, the Attorney General said that in his intervention, but I do not agree that the title of senior counsel and senior attorney are merely honorary, as in truth and in fact, this entitles the senior counsel and the senior attorney to the privilege of sitting at the inner bar, that is, in the front benches of any court of law. And on top of that, claiming higher fees. Hence, it directly results in higher financial reward. Then, neither in the UK nor in India, they accept that it is honorary. I propose, therefore, to delete, Madam Speaker, the word honorary wherever it appears. And I have, and Madam Speaker, I propose to make those amendments at committee stage. À la section 7.3, Madame la Présidente, qui fait mention que la chef juge devra suivre les directives du président de la République. Elle sera obligée d'obéir au président. Et donc, le Premier ministre Madame la Présidente, elle sera obligée, je le redis, elle sera obligée à suivre les directives du président de la République. Et cela veut dire les directives du Premier ministre pour remettre les letters patent dans un délai de 4 semaines. Et elle devient en d'autres mots, malheureusement, je dois me servir de cette expression, leur subalterne, Madame la Présidente. En 10 mois, voilà où nous sommes rendus dans ce pays. Au lendemain de la visite du chef juge de l'Inde, qui nous avait bien sermonné sur la séparation des pouvoirs. Madame la Présidente, je l'ai dit et je le redis, il n'y a pas de transparence dans le processus de sélection. This bill sets out broad criteria for appointment, but does not provide adequate safeguards against irregularity. There is no requirement to publish reasons for selection or rejection. The bill contains no provisions for review, appeal, or reconsideration of the panel's recommendation, as it is the case in other Commonwealth jurisdictions such as the UK, Australia, and India. My question today, Madam Speaker, to this House is why such safeguards have been omitted. The selection of the King's Counsel is transparent. Such a process should first and foremost start with an application from prospective and interested counsels and attorneys. Receiving such application as opposed to mere selections will give more transparency to the overall process. And having received the applications, the panel ought to proceed with selecting those which meet all the necessary criteria, as described under Section 2 of the bill. And then the panel can proceed for the selection through an interview, Madam Speaker. And as an analogy, we should not forget that today, even judges of the Supreme Court are selected after having done an examination as well as going through an interview, Madam Speaker. Madam Speaker, the King's Council panel is comprised of 2 retired senior judges, senior barristers, senior solicitors, and also lay members, that is, persons that are not legally qualified, Madam Speaker. Madam Speaker, regarding clauses 6 and 7, I propose that the following be adopted. That there should be an advertisement inviting those interested to be appointed as senior counsel or senior attorney to apply. The application process must be scrutinized to ensure eligibility of applicants. The eligible applicants must be called for an interview, and the best suitable candidates must then be appointed. Now, let us assume, for example, Madam Speaker, that the Attorney General, the Chairman of the Bar Council, and the President of the Law Society are from the same background, and that those 7 members of the recommendation panel discuss the present list of 20 proposed senior barristers and attorneys. Let us say the 4 judges approve and the 3 other members disapprove. The list goes to the President of the Republic for his assent, and the Prime Minister is not agreeable. The question is, what happens? Est-ce que le Président de la République a-t-il la prérogative d'enlever un nom qui ne lui plaît pas de cette liste? Madam Speaker, the bill also suffers from a striking lack of clarity. It fails to establish any objective or measurable criteria for assessing good standing, integrity, or contribution to the law. These are noble words, Madam Speaker, but without transparency, they become subjective tools that can be twisted to justify almost any decision. Clause 6 of the bill on the selection exercise is very vague and can lead to arbitrariness, Madam Speaker. In selecting an eligible person for recommendation as senior counsel or senior attorney, the recommendation panel will take any of, but not limited to, the following into consideration. First, any contribution made by the person to the development of the law. But this needs to be defined, Madam Speaker. B, any specialized skill possessed by the person in the legal field. This also needs to be defined. C, an academic or other distinction obtained by the person in the legal field. D, the good standing of the person in the legal fraternity. This needs to be defined. Would a clean character certificate be enough, or will there be a certificate of good standing? If so, who will give that certificate? Madam Speaker, what I've said above is so subjective and will be abusively used to reward political friends. The process, as outlined, Madam Speaker, allows for excessive discretion and no right of appeal. In simple terms, it opened the doors for favoritism, inconsistency, and political influence. That is the very ills that a reform of this nature should eliminate. Now, is this the reform our legal profession has been waiting for? Or is it a political exercise to decorate friends and solidify an inner circle of the chosen few, Madam Speaker? This bill risks entrenching elitism under the banner of reform. It creates a hierarchy in the legal profession that rewards the well-connected while ignoring the hard-working. That is, the diligent and the deserving practitioners who serve justice quietly and honorably every day. Now, to add insult to injury, Madam Speaker, at clause 3, subsection 2, we are opening the door to the appointment of non-practicing barristers and attorneys as senior counsel and senior attorney. Je ne peux m'empêcher, Madame la Présidente, de penser que certains de notre côté de la Chambre se frottent déjà les mains. This bill does not empower the legal community. It centralizes power. It centralizes power in the hands of a few. It repeals Section 9A of the Law Practitioners Act without offering a more democratic or transparent alternative. Reform should widen opportunity, not narrow it. Madam Speaker,